Judge, we are waiting on test results from one of our experts in this case.
Last time we had this, we had last setting that it said that would be the absolute last announcement setting. We just go ahead and set up the trial.
Set up trials.
Please, Judge.
All right, set for trial. What about the safeguards we have as conditions of bond here? What are they?
So you're not driving.
No, I don't.
She doesn't.
She's not allowed to drive.
It's one of her bond conditions. She's not. And her father is here. He drives her.
What about using drugs or alcohol? Do you use drugs or alcohol at all? So where do you live with your family?
Yes, sir, with my 2 kids and my dad.
Ma'am?
With my 2 kids and my dad.
All right, well, get a resetting, set it for trial.
Yes, sir.
And then just have a seat over there as well. Thank you.
That's all.
Before you leave. Robert Strahan. Come on up. What's her bond?
Ms. Abshar's $30,000.
Okay. And you are Carly Absher in 22-40965. The court has ordered a urine test, which tested positive for THC tetrahydrocannabinol or marijuana. And one of the bond conditions is do not use drugs, and you're to submit to tests for alcohol and drugs at whim of the court. And under the which what you were charged with this, which is intoxication manslaughter. And now testing for drugs. Here's what we're going to do. Your bond is revoked, and your bond is increased it's doubled to $60,000. You must have a drug patch as a condition of bond. Do you have some kind of a device for alcohol?
She didn't drive a car, Judge. She didn't.
Well, of course, if you happen to drive a vehicle, you would have to have an interlock device. But if she doesn't have a vehicle, then it's just easy for the court to say, do not operate a motor vehicle until further orders of the court. But the next time, it'll be $120,000. Until it gets to a point where you're sitting in jail until all this. And Mr. Gertz just tried a case yesterday that had taken 3 years to finally get to court because of the backlog we have. And there are some people just like you who can't follow the bond conditions, and they're sitting in jail, which if it was me, a day in jail, you can't have that back. And it's a day without freedom, and it could last a long time. But these are choices you make. And my advice is quit whining about it and show the character and strength that you should have to make the correct choices. Well, do it. Unless you're unable to make the right choice. So these are pretty simple, straightforward choices, especially in light of what's hanging over your head here for this charge. I can't imagine. Fortunately, it doesn't happen a lot, but when it happens, we have to make something, it has to have a consequence that's adverse to your freedom. And are you employed somewhere? Yeah, which means to get out of jail, someone else is going to have to pay for it. It's going to cost thousands of dollars. That's what these bad choices, it costs you and or others as well. The thing, just going to take one final step. You have to appreciate and understand that you're not on this planet alone. You got others, right? 7 billion others. We rely on each other for making good choices so that we can have a full life safely. And you got family and friends, I presume, who care for you very much. But they're not going to be able, they're not going to, by law, they can't sit in jail while you're making mistakes. You're a grown up and you have to make the wise choices. And you have to realize that bad choices have consequences. I think you're able to make the right choices. Well, why aren't you making them? Do it. See, there's some people in here who are hopeless. They don't have any hope. Like they're going to make every time they have a chance to make a bad choice, they're going to make a bad choice. I don't think that's you, but these are important mistakes that you have to fix. And you have to remember that your life touches other people's lives as well. Okay, well, fix that. Do it immediately and do much better. Especially you're capable of it. That's what's frustrating to me. It's like, but you've got to, like I and everybody, Mr. Gertz, your family, everyone, we all are held accountable to the choices we make. So make better choices than you've been making. All right, that's the orders of the court. And you're treated similar to everybody else who's in the same situation. Okay, we've got one more test going on in the back. Do we? I think so.
Yes, and I need to fingerprint Mr. Shaw and use French, and then they're ready to go.
Did you fingerprint Sean Principal?
We have Charles Josie next. Mr. Josie, good morning. Mr. Josie, you're here because you've been accused of violating an injunction for protection against domestic violence. Mr. Josie, there is probable cause in the charge. I'm going to see if the attorneys have any additional information before I address your bond. Mr. McDaniel?
No, we just asked. He works at B for Brady's. He's been there for about 5 months. We just asked for a reasonable bond.
For sure.
Ms. Bremer? I'm sorry, Ms. Jeffcoat?
Your Honor, the state does not have any additional information about this case.
Mr. McDaniel, I got your email, but I was confused. It mentions them going to court, but this injunction was months ago. Am I missing something that I need to know about?
You know, I think we have an injunction with 2 people that are very slow. Both of them are, I'm not supposed to say that. He was not, there was some kind of, they went to the court injunction together. It is even in the notes from the injunction, they went together and they left out
way
together,
back. You're talking about, well, you're talking about way back when it was issued, or are you talking about more recently?
No, when it was issued in August, there was a 6-month injunction. You know, I was just saying that they went up there together, and I don't think he or she completely understands anything, you know. And it was a 6-month injunction. I guess somehow or another they've gotten back together or whatever. And then the complaint comes in and there was an anonymous call and he shows up and it just says he found them in their bedroom. I'm not even sure how he got into the house.
Okay.
It's kind of weird.
Is there anybody here on behalf of Mr. Josie in the courtroom? No. All right. So, Mr. Josie, do you have somewhere else you can live other than where Miss Josie lives, or the alleged victim? She may not be Miss Josie. Let's see.
I have been staying somewhere else, Your Honor.
Where's that at?
There's 1938 Wagon Lane.
Okay. You're going to get a bond in this case of $2,500 cash or surety. I'm going to tell you again, no contact means no contact. As long as now you've got 2 court orders keeping you away from her. The first one is the circuit judge in the injunction court. The second one is my condition of no contact on your bond. If I find out you're having contact with her, you're going to go to jail and you're not going to get a bond. Do you understand?
Yes, sir.
No contact. All right. You have the right to post a bond. You'll get to use the phone in just a few minutes, sir.
Judge,
Also, I'm
just
going
for
to ask the
your
jail to give you a
information,
notice for his court date. Mr. McDaniel, what court date would you like him put on? The
February 5th at 9 o'clock.
February 5th at 9 o'clock. You wanted to add something else, Mr. McDaniel?
Judge, yeah, it's my understanding the wife is supposed to be at the courthouse this morning to try to drop the injunction. That terminates, I think, in about 4 weeks. I don't know if it's worth it to go try to get it dropped, but if it gets dropped or when it terminates, you have the objections to them asking the court for contact.
I have no problem with them asking for it. I'm not saying I'll grant it. I want to know more about what's happened for the last 4 or 5 months. And obviously she needs to come in person so the probation office can get her to sign something.
Thank you, Your Honor.
Yes, sir. Have a good day, Mr. Josie. After Mr. Josie, we have Chakisha Dixon. Ms. Dixon, good morning. Ms. Dixon, you're here for first appearance. Good morning, ma'am. You're here for first appearance, ma'am, charged with, you're actually not for first appearance. You're being brought back to try to figure out the status of your case. You got a medical furlough, ma'am, and you were instructed to bring back certain medical documentation, but I think you may have been, actually may have been in the hospital when you got that instruction. So I think you showed up yesterday without any medical documentation. So Corporal, what do we know, or Mr. McDaniel, what do we know about Ms. Dixon? How much of her sentence she completed? When's her tentative release date? That kind of stuff.
Tentative release date's probably a little less than 4 weeks from now, Your Honor. She does work at the laundromat there on Orange Street. But the tentative release date's about 4 weeks from now.
Okay. Corporal, anything else from the jail I need to be aware of?
I believe she had 22 days left. It was either 22 or 23 days left on her sentence when she was given the furlough.
All right. And Ms. Jeffcoat, anything on behalf of the state?
Nothing further at this time, Your Honor.
Okay. Ms. Dixon, given the situation, ma'am, I'm not going to let you out this early. I have no problem letting you out a few days early, but not 3 or 4 weeks, ma'am. I'm just not going to do that. So, Ms. Dixon, what I'm going to do is I'm going to ask the jail to bring you back up 3 weeks from today, and we'll see where things stand at that point. If you've done everything you're supposed to do, ma'am, there's a good chance you're going to get out early, but not 3 or 4 weeks early. Ms. Dixon, do you have any questions?
With me having my job, I am tending to my kid because I'm the only one that's able to take them back and forth to school besides my mom.
I didn't understand your question, ma'am. Can you say it again, please?
Well, never mind. I'm just going.
It's all right. I apologize. Nothing, Your Honor.
Okay. All right. Then that brings us to Stephen Gay and James Crooms. That brings us back to Mr. Godwin. So, Mr. Godwin, good morning again. And good morning. Ms. Kelly is still with us, I believe.
Yes, Your Honor.
Ms. Kelly, give me a second. I apologize for having to ask you to wait that long, but I did not know there was that significant a change in the status of his case. So let me try to pull his case up and see. He's set for trial. I got to find his case first. He's set for trial when?
He was set for trial Monday in case 23707 MM, and then the 23817 has not been set on a trial docket yet.
And which one is the state filed information for second degree misdemeanor?
Originally, they had filed an information for second degree disorderly conduct, and then yesterday they filed an information for second degree trespass in 23817. And that also reflects the statute on the original complaint. He was originally charged under that subsection 2. I'm sorry, subsection 1 also. Okay, so let's go and see what they've done yesterday, because as I said, I wasn't notified. I know his offer, I do remember his offer was 9 months in jail, but at that time it was based upon an understanding that was a first degree misdemeanor. But obviously the state's charged him with a second degree. Go ahead, Ms. Kelly. Ms. Bremer had mentioned that to me, and obviously I wasn't there, but according to the original complaint, which served as the charging document, absent an information, he was charged with a second degree misdemeanor there as well. And I spent quite a bit of time going through several, lots of cases on
quasi-public places like Walmart, the mall, things like that. And they obviously said, of course, someone can be charged with trespass from there, but all of those cases referenced the 81008 subsection 1 statute. I did not spend all day on it, but I didn't come across any where they had the occupied structure statute. And I'm not saying it's not possible. I just didn't come across any.
So he's charged in his original complaint with trespass after warning, and then he says 810.08 subsection 1. That may be what's caused the confusion here.
Yes, sir, and that's the
So let's go
secondary
look. No, because subsection 1B says if there's a human being in the structure or conveyance at the time the offender is trespassed, the trespass and structure conveyance is a misdemeanor of the first degree. So unless Walmart was absolutely empty, it's a first degree misdemeanor, and that's why the plea offer was what it was. But
Your
I
Honor,
have no, Ms. Kelly, the bottom line is it's the state's, let me finish what I'm saying. It's the state's decision to decide how to charge him. It's not mine, okay? So if they decide to charge him with a second degree misdemeanor, that's their call. So let's make sure we're on, now that I got past that hurdle, let me make sure we're on the same page. And I think you had previously entered a plea, basically a straight up plea for Mr. Godwin on 2 second degree misdemeanors. Is that right, Ms. Kelly?
yes, Your Honor.
And Ms. Jeffcoat, is that agreeable with the state?
It is, Your Honor, and it is in line with the email that Ms. Brimmer did send me about this particular case.
Mr. Godwin, do you understand that if you enter this plea, you're waiving your right to a trial and you're also waiving your right to call and cross-examine witnesses at a trial?
Yes, and I will receive 4 months.
The most I can give you is 4 months. That's what I intend to give you is 4 months in jail
Yes,
if you
sir.
enter this plea. Mr.
Yes,
Godwin,
sir.
knowing all of that, is this the plea you would like to enter?
Yes, sir.
All right, Mr. Godwin, I'm going to find that your plea is freely and voluntarily entered with the advice of counsel. Based upon your previous criminal history, I think it's your third arrest in about 6 or 8 months. I'm going to sentence you to 2 months in the disorderly conduct case, and I'm going to sentence you to 2 months consecutive in the trespassing case. There's no
Yes, sir.
public works recommendation. I've got to impose the standard court costs and fines. They are $370 in each case. Mr. Godwin, you've got credit for what you've already done. We're going to ask the jail what that credit is, and you'll get credit on the first sentence, which is a disorderly conduct sentence. And how much credit do you show, Corporal?
42 days, sir.
So you've almost got that sentence completed, Mr. Godwin, 42 days credit on that case. When you finish that sentence, you'll have the 60 days left. Ms. Kelly's been able to negotiate this substantially less than the 9-month offer. So, Mr. Godwin, you actually got quite a bit less, and I'm glad this is over for you and let you move on. The form you're signing now enters your plea and waives your rights that I've already mentioned. And Mr. Godwin, we're going to see if you have any questions once you get that form signed.
Yes.
Your Honor, I have.
Mr. Godwin, any questions?
Can I get public work where I
I'm
can
not
work in
no,
trustee?
I'm not. No, because of your history and you just got out of jail when these things happen, I'm not recommending you for the trustee program. Any other questions?
So I cannot get trustee?
Correct. You cannot. Any other questions?
Listen.
All right, Ms.
So
Kelly,
I
do you
will
have
be
anything else,
doing
ma'am?
day for,
Yes,
I'll
Your
be
Honor.
doing day for day.
Okay, I'm sorry, Ms. Kelly. Let me try to answer his question. No, day for day, not necessarily. Under Florida law, even if you don't get trustee program, you still may be eligible for up to 5 days a month gain time for good behavior. That's a state law that has nothing to do with your sentencing judge. It has to do with you following the jail's rules, and you may get some extra gain time. So if you have a little over 60 days left, you could get 10 or 12 days off of that sentence if you follow the jail rules. I can't promise you that. I'm just trying to answer your question. But it does not mean you'll be due for day for day. The only way you're going to do day for day is if you get in trouble at the jail and you forfeit gain time by not following jail rules. That's the only way you're going to do day for day. Any other questions?
Listen.
Ms. Kelly.
Your Honor, as part of this plea, Ms. Brimmer wanted a $99 restitution to Walmart added. That's part of a review case, and she indicated that if the $99 was assessed and as a part of this plea, she would not be filing on that review case. So we would ask the court to impose $99 restitution to Walmart.
There's another theft case that's at the state attorney's office?
I'm not familiar with that, Your Honor. I don't have an objection to the $99 being.
Yeah, I'm gonna deny that request. I'm not collecting restitution in this case. I think the state's already given him enough of a break. Any other questions, ma'am? Anything else, Ms. Kelly?
Your Honor, since I'm not present and I didn't have the plea forms yesterday, if Mr. McDaniel would be so kind as to just put on the form that I appeared by Zoom, I would appreciate it.
All right, thank you, Ms. Kelly. Thank you for getting involved and getting this case resolved. I know it was set for trial last week and you just got appointed, Ms. Kelly. So I do thank you for getting this resolved on Mr. Godwin's behalf to an agreement that was satisfactory to your client. Thank you very much.
Thank you, Your Honor. Y'all have a nice day.
You too. Have a good day, Mr. Godwin. Okay, I think that's it on the first appearance docket. Mr. McDaniel, did I miss anything on the first appearance docket?
Okay. Let's go. Let's see if we can decide. Yeah.
I need you to sign right there on this.
I'll fill in the rest. I understand. I'm just trying to get this stuff done. Absolutely.
And you are Mr. Trout?
Stroud.
Robert Lee Stroud? Okay, we are all here because the defendant was charged with evading arrest or detention with the use of a motor vehicle. And the complaint here alleges that the defendant in operating his motor vehicle in through major areas of Beaumont was later and driving against traffic and committing other motor vehicle violations. When, no, don't speak. That's rude. I'll let you talk here in a little bit. Just hang by. I'm just talking, I'm just telling, I'm speaking onto the record on what this complaint shows and the probable cause affidavit. And that when you were stopped by the police, it was deemed that you had alcohol in your breath and you were acting erratically. Was there a blood test or a breath test?
Not out of that particular incident, no, sir.
Really? Really? Why wouldn't they have done that? I wonder.
I don't have that answer.
All right. All right. So, you were arrested, later indicted here in, a week ago. No, that was a year ago. January 18th of last year. You were indicted for this third-degree felony of evading arrest or detention with the use of a motor vehicle. Based upon the suggestion that there may be issues involving competency, the court ordered that you be sent to the University of Texas Health and Science Center for analysis on competency. And the court has received a report dated December 14th of 2023 with your cover letter and 8 pages of an analysis plus an accompanying 4-page physician certificate of medical examination for mental illness. Have the parties had an opportunity to review those? And is there any objection to the court marking this set of documents as Court's Exhibit 1 in this case for this date?
I have no objection, Your Honor, but I do want to point out, which I guess you're going to get to in a minute, that we have 2 newer certificates of medical examination, which vary from the finding in December 14th.
We're going to take, I think we do it chronologically.
Yes,
so
yeah.
So is there any objection to this December 14th line?
No, sir.
None from the state judge.
It's been admitted. Now, Mr. Stroud also has an indictment in 23 CR 525 for the third-degree felony of illegal possession of controlled substance, namely methamphetamine, and another 23 CR 526 indictment on May 31st of 2023, alleging that he committed the crime of illegal possession of a controlled substance, namely cocaine. Those alleged to have occurred on August 1st of 2022. But prior to that, he was under prior to those indictments being handed up, he had been indicted on 23-4 and 359, the evading arrest or detention case. So based on all 3 of those cases, the University of Texas Health Sciences Center analyzed the defendant for competency, and the court is on this date admitting Court's Exhibit 1 in these 3 cases. And it is, again, Court's Exhibit number 1. All right. Cover page states that a summary of their findings that the defendant is incompetent to stand trial at this time. And this was in that report dated December 14th of 2023, that the defendant is diagnosed with schizophrenia, an unspecified type, And it was the forensic opinion of the doctor who was in charge of his analysis that he is incompetent to stand trial and is unlikely to be restored within the time frame allotted by the statute. So that occurs. Then on November 29th of 2023, I received a letter from the UT Health Sciences Center where Mr. Strauss had been receiving treatment based upon the findings in State's Exhibit 1. And in that letter dated November 29th of 2023, it states that the defendant who had been admitted in the facility on August 28th of 2023, based upon a finding that he was incompetent to stand trial on the pending charges. Their updated report and analysis of the defendant was the defendant continued to be incompetent to stand trial and requires inpatient treatment. Therefore, under Article 46B.080 of the Texas Code of Criminal Procedure, a 60-day extension was requested by the authorities. So that would have been 60 days from November. So that 60 days actually had not been completed, but here he is. Okay. That's the only thing I'm saying.
No, sir, we have now 2 new certificates of medical examination, one dated January 10th and another one dated January 11th, which changed the outcome based on new reevaluations.
By the way, the court on November 30th renewed the order of commitment, November 30th of last year. Well, I don't have anything else. I don't have them.
These are my copies.
They're supposed to be, I only have 2 orders. Don says there are others.
These were printed online by me when I was furnished to them out of court.
Okay, I see one, a physician certificate of medical examination dated January 10th. I've never seen this before. Yeah.
Which I'm sorry, I don't handle mental cases, but I can go get Kim and see if she has a copy of
Okay.
that.
Thanks.
And then the next one, which is also attached, is dated the next day, January 11th.
I was listening to y'all.
There it is.
Well, they sent it later. Sorry.
It's important everybody else gets it before me. Can review it and so I can just sit up here and read quietly in front of everybody and waste everybody's time.
It's my copy that you're,
That's your copy.
the one I've already highlighted. That's, she just handed you. So,
It looks, okay, I'm going to highlight those both things. What the court is looking at now is two certificates. One dated January 10th of 2024 and another January 11th, 2024. Signed by Dr. Nicola Polizotto. Who analyzed and evaluated the defendant, deemed the defendant is still experiencing the illness of schizophrenia, has been treated, and he was of the opinion that the defendant, based upon his treatment, does not meet the criteria for inpatient commitment at this time. Patient had benefit from treatment. He is now calm, no longer internally preoccupied, and no longer delusional. However, he has poor insight, and he will likely deteriorate if not helped to remain compliant with medicine. Are you getting your medicine? Are you taking it? Do you get it every day?
Yeah,
Okay.
yeah.
For extended, so. Am I reading this right? Sometimes these things don't make clear. It looks like the patient's condition is expected to continue for more than 90 days. And he has received court-ordered inpatient mental health services for a total of at least 60 days preceding this date. So it appears as though that this physician is recommending outpatient commitment.
correct. And the second certificate says the same thing, basically.
And then the second one is a Bharath Raj, Dr. R.A.J. of the same Dunn Center building out of Houston, who also analyzed the defendant, deemed the defendant to be suffering from schizophrenia, and reemphasized his treatment of medicine for the psychosis. And similarly, he states that the defendant does not meet the criteria for inpatient commitment, but meets all of the criteria for outpatient commitment. And patient has been responding to medications, but his progress is fragile. He's at risk for acute decomposition if not ensured to be medicated regularly upon the prescription. So he also states that the condition is expected to continue for more than 90 days. But you see the last, you see the last situation, the last thing right there for extended outpatient commitment And this box is not checked by the physician, and this states does not meet criteria for either inpatient or outpatient. Okay, so it's defaulted, then outpatient commitment is what we're talking about.
That's what they're looking. And based upon that, we feel like, if I can speak, we feel like that we have a window here to dispose of these cases and give them that treatment. So, because.
You see that? I don't understand with that. He said does not meet the criteria for either inpatient or outpatient commitment, but then they said outpatient commitment is
Well,
one.
that was an option. They chose the option up at the top of the page, not the one at the bottom of the page. They have different options in that.
I agree with the interpretation suggestion, Judge.
What does the state say?
Based
upon
Mr. Duzer and I have,
y'all agree?
We've reached, as to what he just said, yes, sir.
So what's the plan?
We've tendered to the court a proposed plea agreement that should dispose of all 3 cases and hopefully help address with a mental health caseload and safety, the issues that exist here.
So physicians, these 2 physicians' certificates of medical examination for mental illness will be marked as courts exhibits 2 and 3 on this date. And
I'm saying that's this back when you're done with that.
yes, and here's where the highlighted ones.
Yes.
Courts exhibits 2 and 3 without objection are admitted into this hearing, which are the physician's certificates for medical examination for mental illness of this defendant that we just discussed. All made part of the record in each of these 3 cases. All right, so the parties then agree based upon this analysis, and you have no other information that would suggest otherwise. The defendant suffers under a mental illness, which is being treated and is competent at this time to proceed with his legal affairs.
Yes.
Are we proceeding on all 3?
We're proceeding on the first 2, and they're going to dismiss number 23 CCCRO 526.
That's correct, Judge.
So the 2 cases are called 23-41359 and 23-CR525. Does the defendant waive a formal reading of these indictments and arraignments? Can we proceed in summary?
Yep.
In summary, 23-41359, Mr. Stroud alleges that on or about May 12, 2022 in Jefferson County, Texas, it alleges that you committed the 3rd-degree felony of evading arrest or detention with the use of a motor vehicle. Do you understand what you're charged with, sir? Sir?
Yes.
Okay. If convicted of a 3rd-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, and that would be up to 10 years in length. And this will run concurrently with the next case, 0525. And a 3rd case, 0526, is to be dismissed. And there will be terms and conditions of probation, which are normal and customary for this type of case. Do you understand?
Yes.
Is that your agreement?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand? What I'm going to do is hold that one in abeyance for just a moment, and we will go to The next one, 23 CR 585. And in summary, this indictment alleges that on or about August 1st of 2022 in Jefferson County, Texas, you committed the third-degree felony of illegal possession of a controlled substance, namely methamphetamine. Do you understand what you're charged with there? Yes, sir. Again, in this case as well, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement has been reached similarly as in the previous case, in this case, that you would be pleading guilty, placed on deferred or unadjudicated probation for up to 10 years. There's no fine here. And this would run concurrently with the preceding case you have pleaded guilty to, and that third case would be dismissed. And there would be the terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the agreement? If I follow this as well, you have no right of appeal of your case. Do you understand? How do you plead to these two cases that you have pleaded guilty to today in 23 CR 525 and 23 41359, guilty or not guilty? Are you pleading guilty in each of these cases, sir, voluntarily and because you are guilty? I'm going to show you in each case what's marked similarly as State's Exhibit 1. Did you sign those documents? Did you understand them, discuss them with your attorney? Are the contents all true and correct? State's Exhibit 1 in each case is tendered. No objection. Without objection, submitted in these hearings. Among other things, these state that you are mentally competent to enter your guilty pleas, which are freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read them in each case. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer in these cases. All of this is true. It states, so help you God. Is that so? State's Exhibit 1 made a part of the record in each case, and pre-sentence report waived. Anything further to add? The state is completely wholeheartedly agreement with this.
Yes, we are, Jeff.
In each of these cases, then, if nothing further, I'm going to find Mr. Stewart, you were pleading guilty voluntarily to these third-degree felonies. You were mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty pleas from State's Exhibit 1 admitted in each case to find you guilty beyond a reasonable. But I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years in each of these cases. There will be terms and conditions of probation, which are normal and customary for each of these cases. Make sure you follow them, because if you fail, your probations could be revoked. You could then be found guilty by the court and sentenced up to 10 years in each of these cases. So it's very important. The 10 years imprisonment. It's very important that you follow all of this. Now, do you understand what has happened today, sir? Now, of course, it goes without saying, we are going to continue this outpatient treatment as prescribed by the two physicians who analyzed the defendant in these cases. The most important thing, it appears, sir, is that the medicine that they are prescribing seems to be helping you. You must take that regularly. You must follow the requirements of the outpatient facility so that your condition continues to be treated and you're stable and you maintain competency. That's very important. That's what you want, isn't it?
No, please.
I'm sorry.
What's it really?
You want to, you're anxious to go move on with your life, right? Are you going to commit to us that you will follow all the rules here? I'm not going to see you again, huh?
I don't know how I'm going against my own self with the law, but
Yeah.
I mean, for right now, until I get this to now, well, yeah, I don't see how.
Where are you going to live?
We can't see, I mean, I understand it right now, you know, before I get out of here. I am the law, BG, the only one talking to me.
Where are you going to live?
I understand anybody. I hear about my,
Your family going to help you?
I have no family.
You have no family.
No, I had a tent, took care of myself for 3 years.
You've been living in a tent for 3 years?
You know, until I get my apartment, I'm fill out application, man, I'm still build apartment on Pro Road. People are trying to get me in.
Where's he going to be attending the outpatient commitment treatment?
Once he gets set up with his officer and gets on that mental health caseload, well, once he does say fee, he's gonna have to do a portion of inpatient after set fee. And then,
Okay, tell me about the substance abuse felony punishment facility. We didn't mention that in this hearing.
It's a condition on probation order. Because that's gonna be, I was just gonna say, that's going to be this initial mental health treatment.
Right.
And they will determine.
So he's not going to be released immediately.
Correct.
Right. He's going to be kept in custody, sent to another facility for this substance abuse to treat you for substance abuse. We've got problems here where you've been charged and pleaded guilty
I want
to the methamphetamine use.
We want to another.
Yeah, but this one is a good facility. Thank you, sir. I signed a dismissal on that other case.
Thank you, Judge.